Any mention? May it please your Lordship, I beg to make a mention of one mention memo, that is WPC number 344 of 2023, Srimati L. Deborah Password versus Union of India. This was the matter which was taken up yesterday, your Lordship, and it was listed for filing of affidavit.
Which one?
Srimati L. Deborah Password. This matter was listed yesterday for filing of affidavit, your Lordship. When we had filed the affidavit yesterday itself, however, on perusing the affidavit, we found some mistakes to which we would like to withdraw the affidavit and file it afresh.
Tomorrow.
Also, your Lordship, I beg to mention item 31, your Lordship. So just a week's time, your Lordship, for this matter.
You are appearing for the petitioner?
Yes, sir. Yes, sir.
Your objection?
No objection, no, sir.
1 week is.
Your Lordship, and similar prayer for item 37 as well.
Who's the other side?
No objection, my lord.
2 weeks is 23 matter. Yes, MS Maniam.
Your Lordship, I beg to mention item 27. 27.
Abdul Hashim Sheikh.
Yes, Your Lordship.
I'm for the private responder, 4 and 5.
Who's for the state? Keep you pressing. Yes, you want what? After 1 week. Yes, 1 week.
Similar prayer for item 40.
Number?
40.
40. Speak louder. Yes. What's this matter
You
about?
have already
Nehu,
informed. Yeah.
you've taken a consent?
Yes, Lordship, yeah. I've already informed.
2 weeks.
I will back.
Please, Your Lordship. Your Lordship, I beg to mention item 41, Your Lordship. I've taken the consent on the other side. Will come after 2 weeks, Your Lordship.
What's the matter about?
It's about the petitioners, the exporters, Your Lordship, of the stone boulder to Bangladesh.
Okay, 2 weeks. Not a pension matter.
No, Lordship.
Okay.
Highly obliged.
Yes.
Your Lordship, I beg to mention item 30 and 35, Your Lordship, on behalf of Miss Ailingwa. She's indisposed, Your Lordship.
30 and
35.
30 and 30.
35, Your Lordship.
But she doesn't argue matters.
Pardon, Your Lordship.
She doesn't argue matters.
She'll be arguing these matters, Your Lordship.
I've never seen her arguing any matter in my court till date. You have argued, but 30 and 35.
Yes,
You're
Your
sure she's the
Lordship.
counsel arguing the matter?
Yes, Your Lordship.
What about S. Lalu? Where's S. Lalu? She left practice.
No, Your Lordship, she's not well.
Okay, 30.
30 and 35.
No, after 1 week. Yes.
Obliged, Your Lordship.
May I please, Your Lordship?
Yes.
32 and 33, my Lord.
Why?
Connected.
What's wrong 32 and 33?
My Lord?
Why?
My Lord, not yet prepared. Well, my Lord.
No,
this-
that's not an excuse. How can a counsel be prepared?
My Lord, kindly grant us 2 weeks' time, my Lord. After that, my Lord.
It's a very complicated matter.
Slightly, one matter is little complicated. There is 4 connected, 4 appointment has been challenged, my Lord.
Okay, after 1 week.
33, I am one of the respondent number 8, my lord. The only contention that they made against me is that they're saying overall, they say that in the advertisement it very clearly shows that any graduate, I am a become. So they have to satisfy become does not belong to a graduate. Is it not a graduate? If it is a graduate, then they have no case against me. So that is the only
Correct.
contention. Can you look at the... Where's the file?
It's okay,
It is
no need.
their
It's-
advertisement.
See, the senior adjournment, we'll have it after 1
And
week.
because of this, my lord, because of this,
Everything's held up.
I have been...
So you have objection to the adjournment. You have objection, we'll hear the matter.
Because of this, my lord, what is happening is that our salaries are not getting released.
No,
my lord.
see, Mr. Yubin,
Yes,
if
ma'am.
you are again the adjourn, we'll hear the matter today. I think
I think we
MS
can-
Rumthal ready also the matter.
Your
Correct.
Lordship, in fact, the counsel who's leading this matter is Dr. N. Mozika, Your Lordship. So,
Yes. So,
Your Lordship, in fact,
I've taken consent from her.
Doesn't matter. You take consent outside means
Yes.
the court doesn't matter. No? When you take consent with the whole list, then court can take a holiday.
My lord is correct.
You just mentions here that we've taken consent that today's list should be passed over. So that's all
My
right.
lord, if my lord wants to hear, then will my lord.
No, I mean he has
The
objection to it.
difficulty that I'm
Yes,
facing, I've been teaching 2
Yeah,
years.
you have objection to it or not for adjourn today? You have objection?
My lord, I am also the same.
respondent.
He is representing one, I am representing 4 respondents, 4 appointees. So we are facing the same difficulty.
Why
Salary
you
is-
want adjournment then?
my lord, we need to prepare on this, my lord.
Okay, 1 week.
My lord.
He's not concerned about your own case. There's no urgency. What
Well,
to
I am
do?
concerned. My lord, highly obey.
Yeah.
32 and 33, my lord, connect. Highly obey.
Yeah.
Supplementary list, item number 1.
Well, please, Your Lordship. Lordship,
Yes,
here the petitioner, my lord, has deposited their hard-earned money, my lord. His hard-earned money in the year 2015, my lord, which is coming to the...
Yes, what are you saying?
The petitioner deposited
Okay. Where,
the hard-earned money, my lord, in the year 2015 on several dates, my lord, which is coming to a total of rupees 4,20,000 only, my lord.
Okay.
But it so happened that in the year 2015, my lord, a scam occurred, my lord, wherein resulting into defrauding of several post offices,
Scam
my lord.
occurred where? In the
In
post
the
office?
William Nagar, in the post office, my lord. Defrauding of several post office saving banks accounts, my lord.
Okay.
So, similar situated persons has already been restored, my lord. Their amount has already been restored and already been refunded to them, my lord. There has been a correspondence
branch.
from same branch, my lord. But several correspondence is also there, my
So
lord.
why they are withholding your money?
The ground which they are saying is, my lord, that I have not submitted my original passbook. But I did submit my original passbook, my lord. It has all been there, my lord.
Yes, sir, Mr. AG movement. Who's going to accept notice?
Your Lordship, I'll be accepting notice on behalf of all the respondents.
All the respondents. Yes, sir. Heard Mr. AG movement council person issue notice. MS Esrum Vice. Mozika is present. Accept on behalf of all the respondents. No further notice called for. This is a matter after 2 weeks for instructions. Yes.
Hello, my lord.
So affidavit, yes.
Item number 2.
May it please, Lordship. Lordship, this matter, Lordship, I'm praying that if it can be listed tomorrow, Lordship. Senior counsel has some difficulty, Lordship, due to
Then we'll take it on
unavoidable...
Monday or Monday at 2 o'clock.
Tomorrow, Lordship.
Tomorrow is a bit difficult.
Lordship.
The caveat also is there.
There's a caveat. Will it start the caveat or will take it up on who's the caveat? I can find. I have praying for the interim order.
Lordship.
Is there any prayer for any interim? I'm praying for the interim orders or not?
Lordship.
They are, but this is the order is passed in
Interim is there,
December.
Lordship. Lordship, but here we're challenging the order of the district council, Lordship.
Are you praying for the interim orders?
Lordship, in fact, there is, Lordship. Yeah.
Okay, anyway. What happened to Mr. Changreso?
Lordship, due to unavoidable circumstances, Lordship.
This is a matter on Monday.
Lordship.
As the senior counsel for the petition not available today, is not available due to personal difficulty. This is a matter on Monday.
Highly obliged.
Daily list, item number 1.
Yes, Mr. Jirwa, obtain instructions. What happened in the hearing? So last time, see, last order was that this for respondent number 4, that the respondent number 4 has taken up the matter, is heard, the matter has been heard.
No, Your Lordship. Actually, the hearing was conducted by the additional DC, Your Lordship.
No, see the last order.
Yes, Your Lordship, but there is some miscommunication in last date, Your Lordship. Actually, the hearing was conducted before the DC, Your Lordship, not before this aim.
How can it be such a miscommunication?
Yes, because
I think my friend misunderstands. If Lordships will see my additional affidavit, page 5 of that, we had received a communication from the CM of Milliam that they are seized of the matter.
Exactly.
Lordships
Actually,
queries on
this-
that issue.
the CM of William has already passed an order, Your Lordship, that deciding that they are the owner, Your Lordship. Based on, because inspection was fixed for inspection, but the petitioner due to rendering for official duty he could not attend. So they decided that.
That's there in the petition itself, man.
Yes, Your
It's
Lordship.
been decided.
Yes, Your Lordship.
But why did this last time submissions made on your behalf that is there are two matters?
No, Your Lordship. There's only one.
No, just one.
Just one.
No,
Your
just one.
In fact,
Yes, last
pursuant
order.
to this order of the 29th of August 22, where they asked us to keep this matter in abeyance, we sought clarification from there via a second letter, which is at page 6, 3rd May 23. We have not received any response to this.
Or the additional affidavit.
Lordship.
After the hearing was conducted by the DC, Your Lordship, then.
No. You have seen this additional affidavit.
Yes, Your Lordship.
What does it say?
This is an application for to keep abeyance under Section 8, Your Lordship. But even after that, Your Lordship, I submitted application before the DC, Your Lordship, seeking that what is the status of the case, but no information, Your Lordship, which compel us to come here, Your Lordship.
You just, Mr. What do you think? Where's the lecture? You said?
So the first letter is at page 5.
Yes.
This is a letter dated 29th of August 22. This reads, inviting your kind attention to the subject cited above, it is to apprise your kind end that as per the conditions stipulated in serial number 10 of the Patta issued by the HIMA, it is requested that your kind end may please keep in abeyance the matter as the office of the HIMA Milliam
Yes.
has proceeded with the adjudication of the dispute. Pursuant to this, we issued a letter dated 3rd May 23, which is at page 6, asking them for clarification on the matter because we had conducted a hearing on the 30th of August 22. The minutes of that hearing are at page 7 onwards. We have not received any clarification on this.
So this is 29th August is their letter. Yes. What is and you're hearing? What happened?
So the parties were only heard, and
They have to furnish written submissions.
Yes, Your
Lordship.
Lordship.
So after nothing proceeded.
nothing proceeded.
And then
We-
before
we filed, Your
has
Lordship,
the matter only been decided. Where is that?
Your Lordship, kindly come to page 69 of the petition.
So nothing remains for adjudication towards the million.
As far as correct.
1 second. Yes. Where is that page?
Page 69 of the Page 69 of the petition.
Yes. So it's confirmed in
Private response.
or who's you're paying private respondent?
I have not received any of these affidavits, madam.
You don't see any affidavits. That's confirmed right for ownership. You are Rekha Rani Das. Then the ownership will be confirmed upon you by the same William. That means Nyota, you have to take recourse to other remedy.
But Your Lordship, here we are filing here under the land transfer regulation, Your Lordship. And in this act, Your Lordship, it says that we cannot go to the civil suit also, Your Lordship, because it bars us. So that is why, Your Lordship, a forum has been created under this act, Your Lordship. But whatever is a contradiction to the provision of this act, Your Lordship, a forum was created, Your
See
Lordship. So we have,
what are the facts of your case first? Let's see what happened.
Which one?
Then you decide the matter.
Section 8 will decide.
yes, Your Lordship.
I'm praying if this matter you will take it up on Monday. I need to seek some instruction on
From whom?
the client matter.
There's nothing, you don't need to take instructions. Only that what happened on the last occasion was that Mr. Sen had filed an affidavit saying that they stopped the proceedings because the matter is being adjudicated by the same William who issued the Patta. Correct? Now, today what transpired is that matter has already been decided, and the as per the same William, it says that you are the rightful, your name is entered correctly, okay, in the Patta, right? So now Their contention is that cannot happen because it is in violation of the land transfer regulation. That matter is still pending before the EDC. So let that go there, then you can take your chance there. Okay. What difficulty?
Fix it on Monday.
Okay. It has been submitted by the Inland Council Respondent number 4 that the matter has since been disposed of. And as such, as far as Respondent number 4 is concerned, nothing remains.
No.
Nothing remains to be done. Stop. Mr. SN. Mr. SN. Mr. SN. Counsel for Respondent number
4,
2
1,
and 3, sir.
2 and 3.
2 and 3.
2 and
1,
2.
2 and 3.
Has submitted that issue of this development. Perhaps the matter can be disposed of by directing the said respondents to dispose of the
Application. My application.
of the petition of the writ petitioner. However, MS Adatta prays that the matter be taken up on Monday to enable to obtain proper instructions. You get instructions, even the seniors are there. Why are you so scared of your senior?
Item number 2.
Please, Your Lordship. My Lord, yesterday we received the affidavit at 5 o'clock. So if I pray before Your Lordship, my learned friend also, sometime we have to give a rejoinder to it. So if it is not inconvenient, Your Lordship, my learned friend, we'll file it and give an advance copy. And if it is not inconvenient, 3rd is okay for Your Lordship, 3rd of, subject to 3rd of April, my Lord.
3rd of April?
3rd of April.
Okay.
If it is not inconvenient.
Mr. Didal, the senior counsel, on behalf of the petitioner, submits that as they have just been in receipt of the affidavit, the matter be adjourned today to enable them to file a suitable rejoinder.
Yes.
Well, this is matter on 3rd of April. 3rd of April? Okay.
2 and 5, my Lord.
2 and 5 both are
2 and
connected.
5, both connected.
2 and 5?
Yes.
Yes, 5. 2 was the first writ petition which was filed.
Oh, right.
And 5 is a termination we adjourned. I am deeply obliged, my Lord.
Thank you.
Item number 3.
Lord, we have filed the preliminary objection in item 3, Lord.
3 who? Where's the petitioner? Item 3, you're a petitioner?
Your Lordship.
Item 3,
Your Lordship.
you are appearing now?
I'm appearing on behalf of Mr. K. Paul, Your Lordship.
Dominic Waji is a practicing lawyer.
Your Lordship.
Then what's his interest?
Lordship, we also
He is the same Dominic Waji who appears in this court also.
Your Lordship.
He's the same, he appears in the High Court. Dominic Waji. The petitioner, he's a practicing advocate, correct?
She's not sure.
Your Lordship,
You don't know?
Mr. Paul is in a position to.
You don't even know who the petitioner is.
Lordship, let it come at the end of the board.
Oh yes, what do you want to say?
I have filed the short objection, my Lord, as to the maintainability in terms of Your Lordship. So then they will seek time for filing the
You
rejoinder.
want to file objection to the...
Lordship, we'll file the reply.
Where's that? Where's that?
Short affidavit on behalf of the maintainability of writ petition.
But delimitation. There's some judgment also.
Exercise, my Lord, delimitation exercise has been questioned.
KHDC also. You filed miscase.
And KHDC has also filed
We
a
also have
miscase.
filed.
Affidavit.
No, we have
Take
filed
down
a petition
miscase 19,
challenging
2024 in WPC number 427. An application challenging the maintainability of the instant petition has been filed by the District Council. Have you filed reply to this?
No, Your Lordship.
When was it filed, Mr.?
It was filed yesterday only, my Lord.
No, your application 7.
You have filed my petition? I don't know. We have
You
not
filed a
received.
miscase?
Yes, your miscase has been filed.
I have filed a miscase, Your
Yes.
Lordship.
Challenging maintainability.
Because etc.
Yes.
You have not responded.
No responded.
Lordship,
Miscase, no? No?
Maybe you have lost interest.
So, this application, no? No, on the no reply has been filed as yet in the instant miss case. Now what should we do? Should you close it? You haven't filed a reply to miss case, they file another objection also.
Let's let the matter be heard, my lords. I've seen the objections. These are objections on law. So I do not really need to plead it. It will be essentially on law. Your lordships will decide, my lords.
You're ready today?
My lords, the objection by the state has just come. So we can have it, my lords, anytime next week.
After 2 weeks, my lord.
An objection to the to maintain the petition has been filed by the state respondents, to which the legal counsel for the petitioner seeks time to obtain the instructions and to approve the same. This is a matter for 2 weeks. The miss case affirm order, the miss case no reply. I had different order sheet to miss case.
What's your blight?
That is also essentially an objection, my lords, but that has come as
a miss case. Yeah, you have to answer it. I mean, that has to be, everything has to be drawn to a close.
My lords.
Yes.
Obliged.
My lord, this is the appointment issue, appointment of arbitrator, and section 29, capital A of Arbitration and Conciliation Act.
Item number 4, if I can.
Yes.
So this requires some hearing, my lord, this 29A.
It's fixed date for hearing, correct? For admission hearing. What's it fixed date for?
Admission hearing, my lord.
Who's to reply? Are you completely?
I have not finished my argument in this matter, my lord.
Who's appearing for that side, Mr. Banerjee?
Yes, my lord, I am for the respondent. My lord, the learned advocate general, my lord, was making a submission.
Yes. Are you ready to matter?
I can do it, my lord.
Yes.
Your lordship your lordship may have it after end of the board, my lord, because
After some time, because other matters will take
other matters will get struck, my lord.
It will take some time. Yes.
Because the Pormi is also the Pormi hearing is also there, my lord, and this hearing is also there, both.
This will take precedence, isn't the order?
Yes.
Yes.
My lord, our only anxiety is, my lord, that the arbitration, my lord, has been really held up. Because, my lord, it has a checkered history.
I will conclude it today, Mr. Banerjee.
I will argue.
Yes, I'm so grateful. I'm so grateful. I'm so grateful.
Item number 6. Your Lordship, I'm here on behalf of respondents, so we were to file affidavit. However, Your Lordship...
Can't find the records anymore.
Your Lordship, that is...
They're lost forever.
Your Lordship, so we have planning to file a short affidavit, Your Lordship.
Yes, MS Golni.
My lord, we have already filed an affidavit, my lord. In fact,
Yes,
my
we
lord,
got money.
the connected matter, my lord, similar issue matter was taken up yesterday, my lord, in which MORTH has to pay to the contractor, my lord, petitioner.
This
who
is
are
what
the same.
project? It's not a hydro project.
No, my lord, it is a road project, my lord.
Regarding bridge?
Way bridge, my lord. Maintenance of way bridge.
Way bridge?
My lord, yes. WPC 444 of 2022, which was listed yesterday, my lord. So it's on a similar footing, my lord. They are praying for payment of the dues, my lord.
Mr. Nobilkar, it's 2007 is a contract.
Yes, my lord, 2007, 2008, but the bills have not been processed nor rejected, my lord. So
Why have you taken so long to come, to agitate for your dues?
my lord, we have been following, my lord. We have been following with them. The bills are not yet rejected, my lord. So.
For the work relates to 2007.
Yes, my lord.
Now, he said that the records are not traceable anymore with the ministry.
Yes, my lord, but the work order was issued by the state government, my lord. Now they are pushing it on the sponsoring my lord, authority.
The bills
that is between them, my lord.
My lord, bills were always been my lord, given to the petitioner and the central government. We were never involved in the billing, my lord. We were only monitoring the work. So, my lord, when it was paid, how it was paid, never information. My lord, we have already filed, my lord. In fact, my lord, in our affidavit, we have also enclosed one letter from the ministry, my lord. Our affidavit was filed on the 1st of August 2023, my lord. 1st August 2023, my lord. The last annexure, my lord, annexure 3, page 19.
Yes.
So, my lord, we have sought information from the ministry, my lord, with regard to the non-payment to the petitioner.
This is a high-level bridge.
My lord, yes.
Not a way bridge.
Not a way bridge, my lord.
Yes, high-level bridge.
Mr. Pasanthi said way bridge.
He said bridge. My learned friend said way bridge.
My lord, page 20, my lord. They have given us the payment details, my lord, so far what they could have traced, share with us, my lord. So that is the payment which they have actually so far given to them. So, my lord, we were never involved in the payment transaction, my lord. It was already always done between the petitioner and the funding agency, my lord.
MS Rumthau, provide of Mozika for response number.
Respondent
4. Submits that as the claim for payment relates to contract which were concluded in 2007. He prays we allow further. How much time?
Your Lordship, 3 weeks time, Your
3 weeks time to file a short affidavit. Yes, this thereafter and so on.
Item 7.
This is a contempt matter, my lord. We were supposed to file a rejoinder. We are filing it, my lord. It's already on the process of filing.
No contempt made down.
No, that is their stand. My lord, first, my lord has to appreciate one thing. That
you can't appreciate anything. You know, file rejoinder.
Yeah, we are. It is on the process of filing, my lord. Let it come after a week, my lord.
Yes. Mr. SD submits rejoinder. We file a course. It is so and so date. Yes.
Item number 8.
See, we have that respondent number 8 yet to file the affidavit.
We have already filed our affidavit, my lord.
2 weeks time maybe, Your Lordship.
It's a long pending matter. Why you require 2 weeks more time? How many times you sought? Once only?
No, twice.
Thrice? You're for number 8?
Yes.
What's your name?
Archival.
Yes, so. Yes, for the 2 weeks time. After this, also.
Item number 9.
May it please your Lordship. Lordship, we need some more time, Your Lordship. What happened? Because this matter is being examined by their personal department. If Lordship is pleased to kindly allow us at least 2 months' time.
In which post?
Well, this is a post of Beyond Mullet in the diet. It's called diet. And Mullet, he was appointed by way of advertisement Mullet in 96, 97.
Not the arrival date.
Due selection process, Mullet. Now, when we sought for promotion, Mullet, when we requested for promotion, the objection is that you were not appointed by the district selection committee. Now, that is nowhere in the rules, Mullet.
Wait, what? We file affidavit then for the 2 weeks time as prayed.
Matter was filed in July, Mullet, 2023. 11. This is the 12th time,
It'll be
Mullet.
3 weeks, Your Lordship.
2 weeks. Expected by on next date after it should be on board. I'll decide it. You have any instructions with you now?
Lordship, is being examined by the personal department.
You won't need affidavit also. On the instructions received, we'll dispose of your matter.
Item number 10.
Okay.
My lord, in this case, exchange of pleading among the party completed. So my lord may pose it for hearing after 3 weeks.
Okay. Yes, the party submitted the pleadings are complete. This is a matter for hearing after 3 weeks.
11.
Deeply obliged.
Please, Your Lordship. 11 and 12 are connected matters. Lordships had noticed in the last order of the 21st of February that numerous opportunities were granted. I'm only praying for just short time of 1 week, Milords. It's ready. We're just waiting instructions on one particular issue.
What cost?
It's just a week's time, Milords. Just a week's time. It's ready otherwise. Just on one issue, we're awaiting some instructions, some additional instructions.
Okay, Mr. S. and senior advocate.
No, Milords, I'm no longer senior GA, Milords. Just GA. I have resigned from that post. I'm just GA now.
Why you taking a demotion?
Lordship, no.
Affecting your professional life. Huh?
Lordship.
Yes. SNLGA praised that submits that though the affidavit was to be on board due to unavoidable circumstances, the same could not be filed in time. He prays we allowed 1 week's time as the last chance to file the same.
I believe the private
is allowed. Prayer for respondent number 5 as well. I'm praying for 2 days time. The affidavit is ready.
Similar prayer by MSR Data on behalf of respondent number
5.
5.
This is the matter after 1 week.
Similar order for the next item as well. Obliged.
13.
As per the last order, we have corrected the cause title. We have taken the steps and the affidavit is yet to be filed.
All have been served.
The cause title, my lord.
No, all have been served. Parties?
My lord, probably the respondent.
You removed respondent 8 and 9.
8 and 9.
You removed them?
No, I didn't.
Your Lordship, the matter was sent to the Lok Adalat on Saturday, Your Lordship, and it appears that in this matter, Your Lordship, respondents number 8 and 9 have nothing to do with this petition, Your Lordship, because he's a Home Guard officer. And
Why you made them party?
Respondents 8 and 9 are food and
Civil supplies.
civil
Why?
supplies, Your Lordship.
I'm not aware of that, my lord. I'll check into it.
You're for the petition,
I am
Guru.
for the petition, my
So you don't know anything about your case, then how will you conduct it?
My lord, this is, I don't know about the respondent 9 and 10, my lord, but the matter pertains to, my lord, not releasing of my increments, that's all.
Okay.
I have superannuator, how?
Your Lordship, respondents 8 and 9 will have to be struck off, Your Lordship.
I'll go into that, my lord. I'll check into that. But so far the correction of the cause title is already done, my lord.
Have you filed affidavit?
Your Lordship, I'm praying for them.
Yes, MS said Leonard GA has submitted that the respondents 8 and 9 who've been arrayed, the response number 8 and 9 are in no way connected to the instant matter and prays that the same be deleted from the array of parties. Stop. Mr. R. Gurung, however, submits that he prays the matter to obtain instructions. This is the matter after 2 weeks for the orders, yes, and for affidavits.
Obliged, Your Lordship.
Item 14.
May it please Your Lordship, we need some more time, Lordship, for filing
Why?
the affidavit. We need some clarification, Lordship.
What's the matter about?
This is implementation of EPF facilities, Provident Fund facilities.
What's your role?
Lordship, we have issued letters to the government of Meghalaya for
Implementing the scheme.
implementation.
Then what happened?
We did not receive any
Here for one number 6.
response.
Are you filing affidavit or not?
I already filed.
Yes, already filed. Very good. So MS NG Shilalas, pays funds allowed 2 weeks for that time to file affidavit stuff. Just after 2 weeks.
Thank you.
15.
Much obliged, Lordship.
My lord, here I am praying for some time.
Your Lordship, I have taken fresh step upon the private respondent on 26/2/2024, Lordship.
They have received?
Not yet, Lordship. The service report is awaited, Lordship.
The officer indicates that service of notice yet to be completed, respondents 5 and 6. Stop next line. Mr. Kibar, she prays how much time?
Well, for 2 weeks.
Yes, for further 2 weeks time to file affidavit. This is a matter of 2 weeks for affidavit and for service report on respondent 5 and 6. Yes.
16.
May it please your Lordship. Lordship, I'm appearing for respondent number 2 in this matter. I pray for 3 weeks' time to
One
file the
second.
affidavit. There for waiting.
I'm waiting for respondent number 3, Your Lordship, and I further pray for 2 weeks' time to file.
Why it taking so long?
Waiting for the instructions, Your Lordship.
Instructions not received also?
No, not yet, Your Lordship.
Your parent
so far as-
Respondent 3, Your Lordship, no.
Yes.
So far as I'm concerned, according to the instructions, the UGC has got no role to play in the instant case. The petitioner is saying that the salary was being paid by UGC. In fact, in the writ petition itself, it is mentioned that the MHRD was paying the salary, and due to the non-funding of by the MHRD, SRC
you
has
file
been
affidavit
closed.
then.
Yes, my lord.
MSP Agarwal for 2 and Mr. Roy for 3. Pray for not for the 2 weeks time. Affidavit.
Much obliged.
Yes,
Obliged,
sir.
ma'am.
17.
Please, Your Lordship.
You file affidavit.
Lordship, we filed affidavit on 29th of February, Lordship.
It's been filed.
Has filed.
Yes, Mr. Sheikh.
Instruction he has filed, my Lordship. What the difficulty he is saying that in the social agreement form that the Gambura has not signed. That is why they are not approving my VEC, Lordship. In fact, the law is very clear. The Gambura is nobody in the formation of VEC, Lordship. If I place the law, Lordship, I don't know why they have make the format including the Gambura. And even if the social agreement first part, Lordship, kindly see page 9, Lordship.
Of the affidavit?
Yes, Lordship. This social agreement made on dash so-and-so, Lordship, between the program officer, block development officer on the first part and so-and-so name of the village employment council on the second part, unless it is repugnant to the context, shall include the secretary and chairman. This is as per law, Lordship.
Where reading?
First part, Lordship. Here, Lordship.
This social agreement on
Yes.
dash day between so-and-so?
Then below, para, Lordship.
Program officer.
Yes, Lordship. He is the first party and the village, that means the VEC is the second party, which shall include secretary and chairman.
So what did you say in affidavit?
They say that in the last, Lordship, for page 14. Page 14 because the
1 second, wait.
hetman did not sign.
But if headman doesn't sign, then you can't implement your VC.
No, Lordship.
But he's the law in the village, right?
No, Lordship. As per the
You see,
amended,
as per law, headman shouldn't sign. That is as per the direction of the government. But then this is just a format, right?
format because different videos having different format, Lordship. In other
This is from the
Southwest, Lordship. In
Southwest.
other blocks, Lordship, they are having only the approval. Based on the election, they used to approve the 5 members, Lordship. And law says that 5 members, 2 will be elected and the rest will be nominated by the VEC, Lordship. And hetman is nobody as per that amended 2000 Act.
Then what was Annexure 2?
Yes, that is the difficulty they have shown, that because the hetman is not signing, because 2 elected members have already been elected, and he was very much present in the election, Lordship, and he was the presiding officer, Lordship. Now his party lost. Now he is not signing. He has put his signature in the counting as a Lordship.
That's in Annexure 3, what does it say? Why do you say that social agreement that formed headman's signature is necessary?
Lordship,
My Lord, for the moment,
if the agreement between the VEC and the program officer,
Lordship,
without the signature of the headman, if the VEC has been, elected, duly elected, I mean, it's not that it's, a body that's unelected, it's been elected in a proper fashion. So why can't it function? Headman's is necessary.
Lordship,
What Mr. Sheikh says is that there's no place for headman in this kind of agreement.
For a moment, Lordship, this is the rule. Lord. This is the amended rule. They are referring that unamended 2006 rule, but 2010.
So it means the program officer doesn't even know about the rules under which he functions.
Now they are referring to 2006 rule. 7A, Lordship. The composition is there, Lordship. Rule 7A, composition.
Hmm.
2 are to be elected.
Yes. When is the affidavit filed? It's come the first time after the affidavit.
Yes, Lordship.
Then you file a short rejoinder and disposal of the next state. Yes, affidavit has been filed by the state respondents indicating the fact that due to the absent signature of the headman of the concerned village, the social agreement could not be signed. Stop. However, it has been submitted by Mr. Sheikh that the headman is not a necessary party with regard to the execution of social agreement. He prays for about 1 week's time to file the rejoinder affidavit. Yes.
This is the composition.
You file, let it come on affidavit, then we'll dispose of it.
This is reservation.
18.
Please, Your Lordship. The respondent state has to file affidavit from the director's reply, man. It's a transfer matter, man.
Number 6. Who's
Number
appearing?
6 notice already been issued and delivered, my lord. We have filed our service affidavit on 1/3/2024, my lord.
Lordship, here I have the instruction to appear on behalf of the private.
Very good. Mr. S. Sheikh, under appearance, we have responded number 6 today. Such service complete. Yes, what do you want? 2 weeks' time.
I'll file my
One more time also. Mr. Khanwala, we have state respondents as also the respondent number 6 pray for allowed 3 weeks' time for affidavit. This thereafter and so on. So.
Hurry up, Lordship.
19.
Hurry up, Lordship.
19.
May I please, Your Lordship? Your Lordship, in this matter, we have obtained a status report, Your Lordship. It was delivered on 9.
Here I have the instruction to appear on behalf of the respondent, Lordship.
Respondent.
Private respondent number 6.
It's a. Who's paying for the state? Respondent number?
Respondent number 6, Lordship.
You also 6. Lucky number 6 for you then. Yes. Mr. S. Sheikh has entered the appearance on behalf of number 6. Such service is complete. So. What up with Khanwala for the rest?
State haven't filed.
For state respondents, for respondent 1 to 5 and newly and Mr. Sheikh for 6 pray for allowed 3 weeks time for affidavit. Just thereafter also.
20.
Lordship, I'm praying if this matter can come up on Monday, my lord. We'll have instructions taken, Lordship. Instructions are yet to be taken, Lordship. We are awaiting instructions, Lordship.
No, but there's been no, the affidavit has been filed, we can close it. If anything comes later on, then he can come again.
Let it be fixed on Monday, Lordship. We'll have instructions.
Why? Because you can't function out your senior.
If some difficulty, Lordship, we'll have
Senior is a mentor or he's a dictator?
Lordship. He's a mentor, Lordship.
He's a mentor. Then you can take your own decisions also.
Lordship, let it come on Monday, Lordship. We'll take instructions, Lordship. Because there are so many petitioners, Lordship, in this matter. So we need to take instructions, Lordship.
Though an affidavit has been filed with state respondents indicating that there's been no orders for shifting of vendors from Labukra to Viranaka Lane. And though Mr. S. Chanda on 29/2/2024 had taken time to obtain instructions, he again prays for
Monday, Lordship.
1 day's time to obtain the same. This is on Tuesday. Yes.
Item 21.
Please, Your Lordship. Lordship, I'm entering appearance for the sole respondent, Lordship. I'll be filing my Wakalata Madi in the course of the day, Lordship.
Very good. Sole respondent.
Yes, Lordship.
MS and Kapchimang has an appearance today on behalf of the sole respondent. Such this service is complete. Stop. She prays for the Lord. How much time?
3 weeks' time, Lordship.
3 weeks time for affidavit. List thereafter and so on.
Obliged, Lordship.
22. Your Lordship, in this matter, I'm praying for some more time, Your Lordship, to obtain
3 weeks'
instructions.
time as prayed by the consul allowed. This thereafter. 3 weeks' time for affidavit
23.
as prayed by the consul allowed.
Lordship, I'm entering appearance on behalf of 6, 7 and 8.
The, for a bank.
Your Lordship, Mr. Edhar is the counsel for the bank. However, he's hospitalized, so...
Who's Mr. Dhar?
Edhar, Your Lordship.
I'll record your name. MFBF Karwanang, Vice Mr. Edhar, as an appearance today on behalf of the respondents 6, 7, and 8. So no further. So the service, as such service is complete. Yes.
Your Lordship, in my case, Your Lordship, we are praying for some time, Your Lordship, to file an affidavit.
As room Tau for respondents 1 to 5. So also for the others and PF Karwanang for respondents pray for allowed 2 weeks time to file affidavits. To obtain instructions for affidavits. The pension matter?
Pension matter, Lordship.
Pension matter, within 2 weeks you get instructions.
Much obliged, Lordship.
24.
Yes.
Please, Your Lordship. An additional affidavit has been filed from the side of the petitioners on 8th of March. There was subsequent development about which, my Lord, I drew Your Lordship's attention on the last day. Your Lordship may kindly see the order passed on the last day permitting me on 6th March. Permitting me to bring on record the subsequent developments that they have taken place.
Where's the affidavit?
Now, the affidavit is filed on 8th of March. And therein Your Lordship will find the photographs that I have produced. And there are also, my Lord, recent photographs taken which shows that they are carrying on the construction still.
Yes, Mr.
Please, Your Lordship. Lordship, if this matter can be taken up at the end of the board, Lordship, the learned Advocate General is leading this matter, Lordship.
No, last time, Miss Rosie had appeared and she had submitted that she has received instructions to appear in the matter. Your Lordship will kindly see the order passed on the last occasion.
Agree, Lordship. But if the matter can be taken up at the end of the board, Lordship, since...
Has the prior respondent been served?
Yes, my Lord. Steps were taken, and thereafter, my Lord, the appearance also may be
on the prior respondent.
AD cards have been received back, my Lord. AD cards have been received back, and there was an order of this honourable court, my Lord, which they ought to have honoured.
With regard to?
Well, Your Lordship passed an order saying that the settlement will be subject
to... That's the last order.
Yes, last
that
order.
Time you came and said that it already started.
Yes.
Yes.
So this is my Lord, in the additional affidavit, my Lord, the photographs have been enclosed.
Subject of outcome of writ proceeding.
Now the difficulty is that, my Lord, if the construction is carried out, then the writ petition will itself become infructuous.
It takes also some time. So all have been served. You are paying for whom? You are paying for prior respondent?
I'm for the state only. I'm just a formal party in this case, Your Lordship.
Who are you?
I'm that respondent number 1, the Commissioner Secretary.
He is only formal party.
No, but you are paying for whom, Mr. Karwanlang then?
Lordship, for the MECL, Lordship, respondent number.
Okay. 228.
228, Lordship.
227.
227, Lordship.
Okay, wait, let the General come.
Second call, item number 4.
I oblige.
Hello, orders for
My Lord, I beg this matter. Lordship, since Learned Advocate General is on legs before the division bench, Lordship, this matter can be taken up.
After what other matter first?
I do oblige.
Don't appear general department.
Hearing. Item 25.
Lordship, this matter also.
Yes.
Your Lordship, in this matter, the respondents are to place some records before this honorable court.
What records?
With regard to the meeting, the records pursuant to the meeting, Your Lordship.
Young, my lord, the records are records, my lord. There, some records are in headquarters, but some of the records are in Jovai, my lord. So, and those records are quite old, my lord, because we have got the compilation.
So records of the last meeting, correct, with regard to the
Last meeting, and then thereafter, my lord,
they owe money to the petitioner.
No, after last meeting, my lord, we have submitted a final closure report. Because this is a central government project and everything is there in that report, my lord. But no, the final report is with the headquarters.
So where is that report?
I will get it, my lord. But the original records where meeting has taken place, those records are in Jovai, my lord. So therefore, we have asked for the.
Okay, I'll just Learned Advocate General seeks further time to produce records as they're located as they are in different locations. When?
After 2 weeks, my lord.
This matter of 2 weeks. Court number 4.
Item number 4.
Have you finished or you still want to continue submit number 4?
Which one?
Number 4, that 29A matter.
29B, I have not finished, my lord. I will start. My lord, I was referring to in 29A, my lord.
Yes.
BSc, no? I was referring to compilation of judgment, my lord.
Because in this 29A, there's no clear cut. There's no clear because it just
Because
refers to
no, your
court.
lordship, if your lordship would appreciate, the issue is that the 29A contemplates a point substitution of arbitrator, my lord. So substitution would require. BSc, what is the name of the file? BSc High Court 29.
Your main ground is that
yes,
if the High Court has the power to appoint arbitrator under
yes,
Section 11.5, 11.6,
yes,
that means even for increasing
and
the
that is
scope
what
and
that is what if your lordship would see the judgment
that it has to come back to the same court.
Yes, my lord, and
And
the basis on which is the there is a definition
for extension of time has come at the same court.
Yes, there is a definition given in the definition clause of the principal civil code.
What is principal civil code?
And then your lordship will see this whole debate, my lord, in the judgment of Delhi High Court. This has been examined in threadbare manner, my lord. Kindly see this Delhi High Court judgment, my lord, at page 79.
Of the compilation?
Of my application itself, my lord. It is there in my application. Page 79.
You have annexed whole judgment?
Yeah, I have annexed whole judgment because this was part of my compilation before. This was part of my application before the learned district judge, my lord, commercial court, my lord.
Page?
And then your lordship will see first paragraph 2, my lord.
Page what page?
Page 79. Sorry, 79 and 79. This is an application filed on behalf of petitioner under section 151 CPC seeking recall of order dated 31st July 2019, paragraph 3. Petitioner has filed the present petition under section 29 capital A of Arbitration and Conciliation Act 1996 for extension of mandate of learned arbitrator. Court had issued notice to respondent. Respondent filed his reply and objected to its maintainability of the petition before this court on the ground of lack of pecuniary jurisdiction as the value of the claim was less than 2 crore. When the matter was listed on 31st July 2019, learned counsel of petitioner submitted that amount of claim and counterclaim in the arbitration proceeding was below the pecuniary jurisdiction of this court and accordingly sought leave to withdraw the petition. With liberty to file the same before the court of competent jurisdiction, the petition was accordingly dismissed as withdrawn, granting the liberty sought. Present application seeks the recall of the order of 31st July 2019. Contention of learned counsel for the petitioner applicant is that power to extend the mandate of an arbitrator under subsection 4 of section 29 of Arbitration Act beyond the period of 12 months or further extended period of terms of subsection 3 rests with the court. Tribunal can extend the mandate by 6 months beyond the initial 12 months with the consent of parties, but any further extension of the mandate can only be by the court. Court has vast power of extension of the period even after such period is over. While doing so, court can substitute one or all arbitrator as provided under section 29(6) and 29(7) of the Act. It is argued that reading the aforesaid provisions, inescapable conclusion is that term court in section 29 capital A would be High Court in case of domestic arbitration, which has exclusive power to appoint arbitrator, not the district court as per section 2(1)(e) of the Act. It is further argued that said interpretation finds force in the fact that it would be inconceivable that legislature would waste the power in principal civil court to substitute the arbitrator who may have been appointed by Supreme Court or High Court. Even otherwise, it would be wholly impermissible, since power of appointment of arbitrator when invoked vests only in Supreme Court or High Court, as the case may be, in terms of subsection 4, 5 and 6 of section 11 of the Act. Hence, civil court cannot give power to extend the mandate of arbitrator so appointed. Learned counsel, in order to substantiate this argument, submit that power of extending mandate and of an arbitrator also includes power to substitute the arbitrator. If in a given case and for valid reasons the court, while extending the mandate of arbitrator, finds that it is so necessary, it can substitute the arbitrator in the same proceeding. Surely power is only with the Supreme Court or High Court given the nature of arbitration, and in case it is to be held that civil court can extend the mandate of the arbitrator, then it would be required to be held that civil court, while extending the mandate, if so required, can also substitute the arbitrator. This would be clearly in teeth of the provisions of section 11 of the Act. A court which does not have power to appoint an arbitrator can certainly not have the power either to substitute the arbitrator or even to extend the mandate of the arbitrator under section 29A of the Act. To say the least, learned counsel submits that conflict can be resolved by understanding the term court for the purposes of section 29A of the Supreme Court, High Court, exercising power under section 11 of the Act, and any other interpretation would contrary to the entire scheme of the Act. It is also pointed out that in fact several courts below have been rejecting application under section 29A of the Act on this very ground that only Supreme Court or High Court would have power to extend the mandate of arbitrator, as the power to appoint the arbitrator lies only with Supreme Court or High Court, as the case may be. On merits of the case, my lord, I am skipping the part of the merits, my lord. Paragraph 14 where respondent contention is there. Next, respondent has 13, my lord, kindly see. Respondent has contended to the present application on two grounds. Learned counsel argues that claim amount excluding interest and cost is 17,79,000, and thus this court does not have the pecuniary jurisdiction to entertain the present petition. He submits that learned counsel for the petitioner had clearly admitted to the fact, therefore withdrawn the petition and with liberty to approach the court of competence, and it is not open to petitioner to now seek recall of the order. Next contention of the learned counsel for the petitioner is that yes. And my lord, in this case 13, it is original jurisdiction. The respondent has taken a plea that the High Court is not having original jurisdiction. That plea was, my lord. And 14, my lord, the next contention of the learned counsel for the respondent that he would have no objection to extension of time for completion of proceeding and passing of the award, provided the court exercise under 29A of 6 of the Act and substitute the present arbitrator with a new arbitrator. He submits that the present arbitrator has been deliberately delaying the proceeding, etc. My lord, after dealing with all these, my lord, the Honorable High Court in paragraph 19, we also will see the paragraph 19 where the judgments are, and then finally 20, my lord, paragraph. The main controversy 21. The main controversy that arises for consideration in the present application is whether petition as filed earlier and subsequently withdrawn by the petitioner is at all maintainable in this court, or the power to extend the mandate of the arbitrator lies with the civil court of original jurisdiction in terms of definition of term court in 2(1)(e) of the Act. In order to decide this said issue, it is important to take note of certain provisions of Arbitration and Conciliation Act. Now, my lord, 2(1)(e). Court means In case of an arbitration other than international commercial arbitration, the principal civil court of original jurisdiction in a district and includes the High Court in exercise of original civil jurisdiction, having jurisdiction to decide the question forming the subject matter of arbitration if the same had been subject matter of suit but does not include any civil court of a grade inferior to such principal civil court or any court of small causes. Now, your lordship, kindly see this section 2(1)(e) proceeds with this line, my lord, unless the context otherwise requires. If there is a requirement in the context to read otherwise, my lord, this definition will not apply. If the context in 29, my lord, if your lordship will see 29A, get the Arbitration Act also. Time limit for arbitration award. The parties may, by consent, extend the period specified in subsection 1 for making award for further period not exceeding 6 months. 4. If the award is not made within a period specified in subsection 1 or extended period specified in subsection 3, the mandate of arbitrator shall terminate unless the court has either prior to or after the expiry of period so specified extended so the period, provided that while extending the period under this subsection, if the court finds that proceedings have been delayed for reasons attributable to the arbitral tribunal, that it may order reduction of fee of arbitrator or by not exceeding.
That means in this 4, that's only where the term court comes.
Yes, my lord, and the substitute and the extension of period may
and
be
also in 5 and 6, that means as per that means a court comes as substitute.
A court can substitute means, and this is the provision which lord the court here means it has to take color from section 11, my lord, because appointment power is with the High Court only. My lord, kindly take a situation where this court has appointed and in exercise of power under section 11 arbitrator, my lord, the mandate requires to be extended, my lord. Then if the application is permitted to be allowed and filed before the district court, commercial court, my lord, and at that stage the issue arises for a substitution of arbitrator, then the district judge will not be having power to replace the arbitrator appointed by the court under section 11, my lord. For that reason, my lord, if your lordship will see 11 and section 22, paragraph 22, my lord, at page 86. Section 11, 5 and 6 of the Act relates to appointment of arbitrator by High Court or the Supreme Court, as the case may be, and details of procedure to do so. In case of international commercial, the power of appointment is vested only with Supreme Court, while in other arbitration, High Court has the power to appoint in terms of Section 5 or 6 of the Act. Section 29A came to be inserted by statute by amending Act of 3 of 2016 with effect from 23rd October 2015. Section has been extracted above. Perusal of section indicate that it provides for timeline within which award has to be made, including timeline up to which tribunal can extend the mandate with the consent of the parties. The power of the court to extend the mandate has no timeline, as is clear from reading of the relevant provisions. One of the important provisions of this section is that power of the court to substitute one or all the arbitrators while extending the mandate, my lord. Kindly mark this line, my lord. Subsection 1 of section 29 provides a time limit of 12 months within which the award shall be made. Prior to amendment of 2019, the starting point of 12 months was the date when the arbitral tribunal entered upon, but post 2019 amendment commencement date is when pleading before the arbitral tribunal are complete. Subsection 3 enables the arbitral tribunal to extend the period of 12 months by further period of 6 months with the consent of parties. Subsection 4 of section 29 provide that if the award is not made within a statutory period of 12 months or the extended period of 3 months, mandate or shall terminate unless the court either prior thereto or after the expiry of the period extended. Extension of course would be granted on an application by any, but only for sufficient cause on such terms and conditions as may be imposed by court. This is stipulated in 5. Section 29 of the Act incorporates an important provision by way of subsection 6 and which in my opinion is relevant for the deciding the controversy in the present case. Provision confers on the court a significant power of substituting one or all or any of the arbitrator while extending the mandate under subsection 4. If need arises and in case substitution is made by the court, the arbitral proceedings shall continue from the stage already reached and on the basis of evidence or material already collected. Therefore, when it comes to the time limit for passing the award or extension of the mandate, section is complete code in itself, my lord. that is when one looks at the definition of the term court under section 2(1)(e) of the Act, it is clear that in case of international commercial arbitration, the court would mean High Court in exercise of ordinary civil jurisdiction, having jurisdiction to decide the question forming the subject matter of arbitration if the same had been subject matter of the suit of the High Court, having jurisdiction to hear the appeal of court or subordinate to the High Court. However, in cases of arbitration other than international commercial arbitration, court would be the principal civil court or original jurisdiction in a district or includes High Court and exercises ordinary civil jurisdiction, having jurisdiction to decide the question forming subject matter of arbitration if the same had been subject matter of the suit. Definition has been substituted by way of Amendment of 3 of 2016, which came into effect from 23rd October 2000. If definition of the term court is looked into, no doubt the contention of respondents seems plausible that power to extend the mandate of arbitrator would lie with the principal civil court. However, on a careful analysis, in my opinion, this interpretation would lead to complications and would perhaps be in teeth of powers of the court under Section 11 of the Act. Thus, the question that poses a challenge is whether the term court can be interpreted differently in the context of Section 29A of the Act. In my view, subsection 1 of Section 2 of Act itself gives the answer, as it begins with the expression in this part unless context otherwise requires. Power to extend the mandate of arbitrator under 29A for beyond the period of 12 months and further extended period of 6 months only lies with the court. The power can be exercised either before the period has expired or even after period is over. Neither the arbitrator can grant extension nor can the parties by their mutual consent extend the period beyond 18 months. Till this point, interpreting the term court to mean principal civil court as defined 2(1)(e) to my mind pose no difficulty. The complexity, however, arises by virtue of the power of the court to substitute the arbitrator while extending the mandate, and this complication is of higher degree if earlier arbitrator has been appointed by High Court or Supreme Court. Coupled with this, conferred the power of appointment of an arbitrator only on the High Court or Supreme Court, depending upon the nature of arbitration and as and when the power is invoked by either of the parties. There may be cases in which, while extending the mandate of arbitrator, the court may be of the view that some valid reason the arbitrator are required to be substituted, in which case the court may exercise the power and appoint a substituted arbitrator and extend the mandate. In case a petition under 29A of the Act is filed before the principal civil court for extension of mandate, an occasion for substitution arises, then the principal civil court will be called upon to exercise the power of substituting arbitrator. In a given case, the arbitrator being substituted could be arbitrator who had been appointed by the Supreme Court or High Court.
There's only a point that makes some sense. In a manner you have to substitute amounts of fresh.
This is one argument, my lord. This is one argument, and their whole case is based on the definition given in 2(1)(e). That
exactly, but then
but
that
the
High Court here doesn't have original jurisdiction.
And the question is not of original jurisdiction. Question is because 2(1)(e) proceeds with the line unless context requires otherwise. So that
unless context, that means that contextually, that means that there is no scope for.
So if the context requires different definition to be given of the court in 29A, my lord.
Yes.
If your lordship kindly see page 85 where the definition starts, my lord.
So this is your blue ribbon judgment for the case.
The other judgments are also there, which supports my contention. Even Supreme Court recent judgment is there. Your lordship will see unless the context otherwise requires. So the defined meaning in the Act can be substituted if the context demands different interpretation so far as 29A is concerned, my lord.
Yes.
Because their whole case is that the 29A use of expression court in 29A will get same meaning as defined in section 2(1)(e). This is their case. My case is that when definition clause itself says that unless the context otherwise requires, the court has to have different meaning. Your lordship has seen in Delhi, the 29A applications are not being entertained by district court, which the reference has been made. All those applications are being filed before the High Court, not on the ground that the High Court is having principal civil original jurisdiction, on the ground that the High Court is the only court which has the power to appoint in case of domestic arbitration, the arbitrator, my lord. Now, similar situation arose, my lord, one more paragraph and then Lordship kindly see. This reasoning is, I commend your Lordship to accept this reasoning, my lord, and there are 29, paragraph 29.
Yes.
In case 29.
Yes.
In case a petition under section 29A of the Act is filed before the Principal Civil Court for extension of mandate and the occasion for substitution arises, then Principal Civil Court will be called upon to exercise the power of substituting the arbitrator. In a given case, the arbitrator being substituted could be an arbitrator who had been appointed by Supreme Court or High Court. This would lead to a situation where conflict would arise between the power of Superior Court to appoint arbitrator under section 11 of the Act and those of Civil Court to substitute those arbitrators under section 29A of the Act. This would be clearly in teeth of provisions of section 11 of the Act, which confers the power of appointment of arbitrator only in the High Court or Supreme Court as the case may be. The only way, therefore, this conflict can be resolved or reconciled, in my opinion, will be interpreting the term court in the context of section 29A of the Act to be the court which has the power to appoint an arbitrator under section 11 of the Act. Accepting the contention of respondent would lead to an inconceivable and impermissible situation where, particularly in case of court-appointed arbitrator, where the civil court would substitute and appoint arbitrator while extending the mandate under section 29 of the Act. So this reasoning, my lord, of the Honorable High Court, my lord, this rationale of the Honorable High Court, in my humble submission, my lord,
yes, the ratio should be adopted.
It should be adopted for two reasons, my lord. That the defined meaning of which is given in 2(1)(e), my lord, of the court precedes with the language in the context otherwise requires. And here contextually, my lord, it requires otherwise. There is a judgment, my lord, kindly see in section 14 also of the Supreme Court judgment, my lord. Last time I handed over a copy of that judgment, my lord, where in section 14 also, my lord.
Swadesh Kumar Agarwal.
Yes, my lord. Kindly see that judgment, my lord.
Yes.
Swadesh Kumar Agarwal judgment, my lord. In at section 14. Kindly see this judgment, my lord. First, kindly see section 14, my lord. There also the issue is who will appoint the. The next question which is posed for consideration of this court is whether, in exercise of power under subsection 6 of section 11 of the 1996 Act, High Court can terminate the mandate of sole arbitrator and substitute the arbitrator in view of 14(1)(a) of 1996 Act on the ground that he failed to act without undue delay, and such a situation aggrieved party has to approach the court to terminate this mandate. While answering the aforesaid issue, the relevant provisions of 1996 Act, my lord, the provisions have been taken note, my lord. Then kindly see paragraph 18, my lord. Section 14 and 15 provides for termination of the mandate of arbitrator. Section 14 of 1996 Act provides that mandate of arbitrator shall terminate and he shall be substituted by another arbitrator in case of any eventuality mentioned in 14(1)(a). As per subsection 2 of section 14, if a controversy remains concerning any of the ground referred in clause A of subsection A, party may apply to the court to decide the termination of the mandate. My lord, now 2(1)(e) has been referred to, my lord, and then 21, my lord. Therefore, a conjoint reading of section 13, 14 and 15 of the Act, if the challenge to arbitrator is made on any of the ground mentioned in section 12 of the Act, the party aggrieved has to submit an appropriate application before arbitral tribunal itself. However, in case any of the eventualities mentioned in 14(1)(a) of 1996 Act and the mandate of arbitrator is sought to be terminated on the ground that sole arbitrator has become de jure or de facto unable to perform his function or for other reasons failed to act within undue delay, aggrieved party has to approach the court concerned under 2(1)(e) of 1996 Act. The court concerned has to adjudicate whether the fact sole arbitrator has become de jure or de facto unable to perform his function or for other reasons failed to act without delay. The reason why such a dispute has to be raised that court is that eventuality mentioned in 14(1)(a) can be said to be a disqualification of sole arbitrator, and therefore such a dispute controversy will have to be adjudicated before court concerned and provided in 14(2). So far as the termination of mandate of arbitrator, my lord, last 4 lines, my lord, will say middle of the page. Hence, there is a dispute or controversy that mandate of arbitrator is to be terminated on the ground mentioned in 14(1)(a), and such controversy has to be raised before the court concerned only after decision of the court concerned and defined under 2(1)(e) of the Act. Ultimately, it is to be held that mandate of arbitrator is terminated. Thereafter, arbitrator is to be substituted according to rules that were applicable to initial appointment. Therefore, normally and generally, the same proceeding is required to be followed, which was followed at the time of appointment sole arbitrator. Now the question, and then your lordship will see paragraph 35, my lord.
Paragraph 25.
35.
35.
Yes, my lord. To do the substantial justice between the parties and to ensure that respondent 1 and 3 are not left remediless, we direct the
class is only that, like whatever might be court, might be anything.
Yes.
But the very fact that you come to 6, that some substitution also is run by the same court concerned.
Yes.
And substitution amounts to appointment of a fresh, arbitrator.
Yes, Lord.
Which is only given under Section 11.
And therefore,
so that means that the district court will have.
And 2(1)(e), because the whole case is based on the entire case is based on the definition given in Section 2(1)(e) of arbitration, and definition that, and on the ground that High Court is not having original jurisdiction. Issue is not of original jurisdiction. Issue is who has the power to appoint the arbitrator, and therefore the word court in Section 29A will get color from Section 11. And also get color from the definition unless context requires otherwise. My lord, I have 2 judgments on this issue. What is the meaning of word context requires otherwise? Whether the defined meaning.
Context requires otherwise.
Context requires, my lord. 2 judgments, my lord, on the very issue that dictionary or the defined meaning in the Act may not be applicable to the other provisions of the Act, my lord, that your lordship will see. First, your lordship kindly see Whirlpool judgment, 1998, 8 SCC, page 1. Paragraph 28. Now, the principle is that all statutory definitions have to be read subject to qualification variously expressed in the definition clause which created them, and it may be that even where definition is exhaustive in as much as the word defined is said to mean a certain thing, it is possible for the word to have a somewhat different meaning in different sections of the Act depending upon the subject or context. If the context and subject requires different meaning, my lord, the defined meaning may not be followed or borrowed, my lord. This is why all definitions in all statutes generally begin with the qualifying words similar to the words used in the present case, namely, unless there is anything repugnant in the subject or context.
So how do you... Yes.
Thus, there may be sections in the Act where meaning may have to be departed from on account of subject or context in which the word has been used, and it will be giving effect to the opening sentence in the definition section, namely, unless there is anything repugnant in the subject or context. In view of this qualification, the court has not only to look at the words but also look at the context, the collocation and object of such words relating to such matter, and interpret the meaning intended to be conveyed by use of words under those circumstances. So this is, I request your lordship that this definition given in the Arbitration Act may not be applicable to Section 29A where the expression court is used, and that expression, my lord, has to be read in the context of Section Power of the Court to appoint arbitrator under Section 11. My lord, the next judgment is, my lord, 2002 1 SEC 589.
Contextual, therefore, has to be read strictly in terms of Section 11.
Yes, my lord. Because it would lead to anomalous interpretation where the district judge or principal civil court will get the power to substitute the arbitrator appointed by High Court, and under Section 11 the principal civil court has no power to appoint the arbitrator, my lord. Power to appoint the arbitrator is only vested with the High Court or Supreme Court. A A bare perusal of section 2 of the Act, para 8, I'm sorry, my lord, para 8 of the judgment.
Indian Medical Association?
Yeah, Indian Medical Association, my lord. A bare
Para
perusal of section 2 of the Act shows that it starts with the words, in this Act, unless the context otherwise requires. Otherwise, let us find out whether in the context of provision of section 64 of the Act, the defined meaning of expression management can be assigned to the word management in section 64 of the Act. In para 3 of the regulation, the essentiality certificate is required to be given by state, and permission to establish a new medical college is to be given by state government under section 64 of the Act. If we give the defined meaning to expression management occurring in section 64 of the Act, it would mean that the state government is required to apply to itself for grant of permission to set up a government medical college through the university. Similarly, it would also mean that the state government applying to itself for grant of essentialities under paragraph 3 of regulation. We are afraid the defined meaning of expression management cannot be assigned to expression management occurring in section 64 of the Act. In the present case, context does not permit or requires to apply the defined meaning to the word management occurring in section 64 of the Act. So in my humble submission, my lord, the defined meaning of the quote in 21E may not apply and should not apply to section 29A of the Act, my lord. Now, some of these authorities have been cited by the other side, my lord. I will distinguish them in 2 minutes, my lord. All those judgments, kindly see their compilations, my lord.
It's with me?
They have
given compilations?
Compilation.
Given?
Yes.
Should have been filed, my lord, I'm sorry.
My lords, we have filed the compilation.
Langbang.
Yes. Okay. First judgment, my lord.
You haven't given compilation. You not given any compilation.
No, only that I have relied on the High Court.
Only on the petition, next the judgment.
And judgment and two. Yes.
Okay. Yes.
I can give the same judgments, my lord. I can put in.
Necessary. Just no need to waste paper.
Yes, my lord. Now, first judgment is, my lord, this Exino Capital Services. Exino Capital Services, my lord. By Allahabad High Court, my lord. Kindly see paragraph 2 of the judgment, my lord. Para 2. What was the issue posed by Allahabad High Court judgment in this case, my lord? Issue under the my lord.
Internal page?
Internal page, my lord, is 1. Page 1, my lord, paragraph 2.
Okay, yes. Issue under consideration.
Is with regard to extension of time under 29A4 of Arbitration and Conciliation Act 1996, with the question involved being now whether the concept of court as envisaged under section 29A read with section 21E of the Act would include a High Court not having original civil jurisdiction as in the case of Allahabad High Court. So question wrong, in my humble submission, my lord, wrong question has been posed. Question should be whether the High Court has power to appoint the arbitrator, because the dispute is not with regard to original civil jurisdiction. Dispute is with regard to who has the power. If you pose wrong question, my lord, you will definitely get wrong answer, and that has happened in this case, my lord. And the coordinate bench judgment has also been distinguished by this in this judgment. Coordinate bench taking different view, saying that judgment is per incurium, my lord. That is also unheard, my lord. Kindly see paragraph 19, my lord. Because in all the judgments, the issue is all judgments are confused with the term.
Give me 2 minutes. Let's come back. How much longer you'll take?
Barely 15-20 minutes, my lord.
Okay.
I was taking your lordship through this ex Kenko capital judgment of Allahabad High Court, my lord, and I have shown, my lord, the paragraph, the question which has been posed, my lord.
Para 2 you read. Now
Para 2 I have read, my lord, and then, my lord, para 19, my lord. It has been contended by. It has been contended by learned counsel for the applicant that the word unless the context otherwise requires, appearing at the start of section 2 of the Act, are material and indicates flexibility in the definition clause. However, the aforesaid words have clearly been explained in Honorable Supreme Court in Nimit Resources, my lord. I will place that versus ISAR is still limited. The definition of court indisputably would be subject to the context in which it is used. It may also include appellate court. My lord, kindly mark this. Once the legislature has defined a term in the interpretation clause, it is not necessary for it to use the same expression in other provisions of the Act. It is well settled that meaning assigned to term defined in interpretation clause, unless the context otherwise requires, should be given same meaning. It is also well settled that absence of any context indicating a contrary intention, the same meaning would be attached to the word used in later. If the my lord, if the context requires contrary intention or different intention, my lord, different meaning has to be given. This judgment is in my.
In the absence of any context indicating contrary intention.
The intention, my lord, in the context is, in our case, my lord, is context is that the word court in 29A means court even of the appellate. If your lordship will see, court indisputably subject appellate jurisdiction also. So if the context.
So you say that contextually is present in indicating a contrary situation.
I am saying not contrary, my lord, different meaning. Here, okay. Here different meaning, because different meaning will be High Court. In 29A, different meaning will, and this Nimit is supporting me in the sense that if the context requires different or contrary meaning, my lord, that has to be given, my lord.
Okay.
So, my lord, after the aforesaid judgment was rendered explaining the definition of, now kindly see paragraph 20.
Yes.
The aforesaid judgment was rendered explaining the definition of court with regard to application under section 14 of the Act of 1996, and it is clearly provision the word or expression used in statute are to be given same meaning. This is, in my humble submission, my lord, it is incorrect reading of the law. In absence of any context indicating a contrary intention, the word have been explained in Supreme Court in the case of Pandey Company Builders, reported in so-and-so. It has been held even a definition clause is preceded by word unless the context otherwise. Normally, definition given in the action should be applied and given effect to that to frame of any definition more often not is capable of being made flexible, but precision and certainty in law requires that it should not be made loose but kept tight as possible. Learned counsel for applicant themselves have adverted to judgment of the Supreme Court in so-and-so. Now, my lord, kindly see the paragraph 32. The view taken by coordinate bench, my lord, which is of Allahabad High Court only, which is different from the view taken by learned judge in this case, my lord. The learned counsel for the applicant have placed heavy reliance upon the judgment rendered by coordinate bench of Indian Farmers Fertilizer Cooperative versus Manish Engineering Enterprises, SEC Online, Allahabad 150. Aforesaid judgment rendered by a coordinate bench of the court has specifically gone into the aspect of definition of court as envisaged under 29A of the Act, has held that the application for extension of time for arbitral award filed under 29A would be implemented before the court, even though not having original jurisdiction. A perusal of judgment makes it evident the proposition of law followed in this judgment indicated in following. Once the appointment of arbitrator 11, my lord, this 11, the 11 concept. Now 34, my lord. As per the judgment, the primary aspect of
just because they don't jump too much.
I'm sorry. I'm sorry. I'm trying.
I'm not as
I've read 2-3 times that way. So
that's the thing. You're jumping straight. You're reading 30, then you're jumping.
No, first
here,
I'll slow down.
Instead of
I'll slow down.
Enlightening is becoming.
No. I'll slow down, my lord.
Yes.
I'll slow down. So this judgment, my lord, the before this judgment, the reliance is placed of the Supreme Court in Nimit, my lord. Nimit judgment of Supreme Court. Nimit judgment is clearly saying, or in clear terms it says, my lord, if the context requires other meaning to be assigned to the word used in the various statute, it can be given other meaning. Not necessarily the meaning defined in definition section of the statute, my lord. So, and this view has already been taken by a coordinate bench of Allahabad High Court, saying that in section 29A, court would mean High Court, not the principal civil court, my lord. Now the coordinate bench is the distinguishing and saying that this is per incurium, my lord. In my humble submission,
your decision is correct.
This cannot be, because
by your submission that this other Indian farmers fertilizers the correct decision, correct proposition.
Correct proposition, and I basing my argument on 3 proposition, my lord. 29, because I say the definition clause is not the only basis for defining the various terms used in the statute, my lord.
Because the context is different.
And
you are trying to the whole basis is that that contextually.
Yes, Lord. My basis.
Court with regard to 29A.
Yes, my lord.
Will have a different meaning of what 21E says.
21E says,
that's your basic premise.
That's my fundamental premise, my lord. That is my. I can't digress. That's the only basis.
So that's the only
basis on which I can.
Your first point is that if substitution is allowed, substitution to be done.
Yes, my lord.
That means that it can, if the appointment of arbitrator is done by the High Court.
Yes, my lord.
And if substitution is allowed to be done by the district court, district judge, that amounts to the appointment of a new arbitrator by the which is not allowed by section 11.
Yes, sir. The situation may arise where, my lord, there is no intervention by the court for appointment of arbitrator.
Well, that's different.
And the situation.
No, that'll be a different
there could be
scenario.
No, even in that situation, my lord, also, because for example, it so happens, my lord, that one party appoints A arbitrator, B party appoints C arbitrator, and both of them have to choose the third arbitrator. There is a dispute, or they do not come to the conclusion that so and so to be appointed. In that case, also application lies before your lordship. Now they will say that, look, so far as appointment of arbitrator by party A is concerned, that power has been exercised by the party. Therefore, for that, there is no intervention required at the stage of the High Court. But ultimately, when it comes to substitution, my lord, whether...
So whenever you say that, whenever the appointment comes,
yes, my lord,
in any manner, section 11 is attracted,
yes, my lord,
then 29E will go back to a court who has exercised
and that is the
11E.
view, and that is the view in my humble submission. That is the view in my humble submission has correctly taken by the Honorable High Court of Delhi, and the practice has also been followed. And Allahabad High Court also, your lordship, has seen that the basis is the Nimit judgment of the Supreme Court, where the interpretation was in the context of section 14, my lord. I have shown in Swadesh Kumar, my lord, the recent judgment of Supreme Court, where the court again has been interpreted to mean court under section 11 when it comes to appointment. After termination, my lord, that stage is there. So therefore, this judgment, my lord, in my humble submission, holds no ground, my lord. The second judgment is...
no persuasive value also.
No persuasive value, that is the second judgment, my lord, is magnum opus, my lord.
Okay.
And that magnum opus starts from page 26, my lord.
This case is not make it to a magnum opus.
So these days, so page, the judgment is... Sorry, page 45, it starts from page 45, my lord. Page 45. And paragraph, my lord, is... kindly see paragraph 2, my lord, facts. The writ petition raises challenge to the order dated 3rd February 2021, whereby learned district judge allowed the application filed by respondent under section 29A of the Arbitration and Conciliation Act and appointed retired judge Vivek R. Agrawal as the sole arbitrator. And they kindly see the paragraph 18 now. From a plain reading of this provision, it is clear that in the case of international commercial, the court mean High Court in exercise of its ordinary civil jurisdiction, having jurisdiction to decide the question forming the subject matter of the arbitration, if the same had been subject matter of suit or court, so and so. So say, my lord, the meaning of original civil jurisdiction. All the judgments, my lord, is based on the defined meaning of word court. Now kindly see 28, my lord. This judgment is based on the defined meaning of
In arbitration proceedings other than international commercial arbitration,
Yes.
court would mean the principal civil court on jurisdiction in the district and includes the High Court in the exercise of ordinary original civil jurisdiction.
Yes.
Arbitration to decide the questions. Okay.
So that is the basis, my lord. And kindly see one more distinguishing feature, paragraph 28. At page
Yes.
it is pertinent to note, page 54, my lord. It is pertinent to note that pursuant to the order of district court, the petitioner submitted to the jurisdiction of arbitrator without any objection.
Yes.
It was only on the subsequent hearing that petitioner questioned the jurisdiction of arbitration. So therefore, this case at best will turn in the facts of the case only, my lord. Facts. Then third judgment is, my lord, page 56, Leela Ditya Dev. Now, Leela Ditya Dev, my lord, kindly see paragraph 15. From the above, it becomes clear. Page, paragraph 15, my lord, at page 61.
Yes.
From the above, it becomes clear that arbitration proceeding initiated here and above was disposed of on a consent of parties, and there remains no doubt that there was merely an appointment of the arbitrator in exercise of power under 11.5 and 11.6 of the Act. So far as the question of jurisdiction of the court is concerned, this court finds from the cause title of the writ petition as well as arbitration petition that petitioner Leela Det contested the arbitration proceeding whose address is so and so and so and so in the district court. Present opposition is as well as the petitioner both in and resident of so and so, my lord. After that, my lord, kindly see page paragraph 20. There is no argument what is being canvassed and addressed before your lordship, my lord.
These arguments you're making now would be more of a rejoinder argument because the other side have not placed these decisions as yet.
Yes, my lord. Because those judgments have been supplied.
You're only making a rejoinder argument now.
No, because the judgment
before the submissions have been advanced by the other side.
Only one or two paragraphs so that the matter will. I put everything in context, my lord. That is so contextually, my lord. Paragraph 20, my lord. Further, on the basis petitioner failing to establish the district court judge, Bhubaneswar is not the court in terms of decision of section 20E as to undertake exercise of 29A. So, because all these judgments are turning on the proposition, my lord, that the district court is original principal court, principal ordinary, and therefore
principal civil court. Yes.
Principal civil court, my lord. Then, my lord, kindly see Nimit. The Supreme Court judgment at 94, my lord.
What about the 74?
Your lordship, the 78, I'll show the
Kerala.
Kerala, my lord. Ek, my lord, only one paragraph at page, paragraph 5, my lord. Kindly see paragraph 5 at page 77. In my view, the aforesaid observation of division bench pertains to the case where the initial appointment of arbitrator is by the High Court under section 11 of the Act, and not to cases such as present where the initial appointment of arbitrator was parties, my lord. This very line shows, my lord, that two types of two courts, my lord. There can't be two courts for 29A. One, when the appointment takes place under the order of your lordship under section 11, and one when party appoints, my lord. That this kind of approach, and my lord, the example which I gave earlier, that there will be situation where court may not be called to appoint the arbitrator at the initial stage, but but when the dispute will arise with respect to substitution, my lord, then the power of appointment under section 11 will kick in.
Then contextual won't come in there again.
And contextual rule will be there all along.
If you look everything on a case-to-case basis, then contextually won't that apply also?
So contextually, my lord,
yes.
yeah, contextually, my lord, what is the in case of 29A, my lord,
yes.
the power has to be exercised by the district judge for substituting the arbitrator, my lord. At that stage, my lord, whether district judge is competent to appoint the arbitrator. If district judge is not competent to appoint the arbitrator, then the term court will not take color from the defined meaning, because it is not.
Why can't legislature just amend the act? It takes me one small amendment to do it. I mean, like, instead of breaking heads,
I'm absolutely correct, my lord. I'm grateful, my lord, for that.
That's the
what
thing.
fell from my lord.
That is there.
Yes. Yes. Next.
Yeah, my lord, the basic proposition is that exercise of power will not change the existence of power, my lord. Exercise of power, what I am trying to say, my lord, who will exercise the power of appointment? So then on that basis.
So the source of the arbitrator is irrelevant. It's only that what happens.
Yes, my lord. And then your lordship kindly see Alpas at page 78.
A plus.
Yeah, A plus. And 27, my lord, at page 84.
27.
Yes, as page.
Yes.
27, my lord. The basis is, as noticed above, in terms of definition, clause 2(1)(e) of the court means principal civil court of original jurisdiction in district and includes jurisdiction high court in exercise of original jurisdiction. Therefore, it is quite clear court would mean principal civil court of original jurisdiction, and also high court. Guwahati High Court does not exercise ordinary civil. So all these judgments, my lord, is based on that the High Court is not exercising original civil jurisdiction, and therefore the defined meaning has to be. In defined meaning in section 2(1)(e) has to be held. That would causing violence to section 11. That would be causing violence to the context when context requires otherwise, my lord. That 2(1)(e) the definition clause and these two judgments. So therefore, whatever court has been meant, my lord, in that, and then my lord kindly see next judgment is UCC. This 88, my lord, page 88.
QRC.
Yes, no, my lord, Chief Engineer versus Devdutt R.C. Rodkar, and paragraph 6 at page 89.
I've carefully considered.
And 10th line.
Yes.
10th line from the bottom, my lord. This judgment is premised on its own fact. It was not disputed during the course of argument at bar that district court would have jurisdiction to appoint substitute arbitrator in the place of arbitrator whose mandate had left. So if there was no dispute, my lord, there was no list. This judgment is of no help, my lord, because there was no there was no dispute raised. That
so as per according to that the Delhi High Court is the judgment that is
Delhi High
correctly translates the
Delhi High Court, even my lord,
correctly articulates the entire 29 vis-a-vis
and
11
even my lord,
vis-a-vis
Allahabad,
section 2(1)(e).
Even Allahabad High Court, my lord, the coordinate bench of Allahabad High Court has also correctly interpreted, my lord, and none of the judgments which have been cited by respondent, my lord, they have examined the clause section 11. None of them have examined the definition of 2(1)(e), which proceeds with the preceding line.
Contextual.
So context, none of the judgments, my lord, and none of the judgments have examined, my lord, 11.6 and 11.7 of power, my lord. And kindly see the 11.6, who will have the power? Substitution necessarily include appointment, my lord. And kindly see, my lord, 29A6 for a moment.
Yes.
And expression itself in 29.6 is mentioned appointment, my lord. Kindly see 29 capital A6, my lord. And in none of the judgment, my lord, this aspect has been dealt. while extending the period 29A6, my lord, while extending the period in subsection 4, it shall be open to the court to substitute one or all of the arbitrator, and if one or all of the arbitrator are substituted, arbitral proceedings shall continue from the stage already reached and on the basis of evidence and material already recorded, and the arbitrators appointed under this section shall be deemed to have received the said evidence and material. So the 29A uses two expressions, my lord, appointment and the court, my lord.
Okay.
So appointment will also get color from power under section 11(6), my lord. And your lordship kindly see 29A7 also. 29A7, my lord. In the event of arbitrator being appointed under this section, the arbitral tribunal thus reconstituted shall be deemed to be in continuation of previously appointed arbitral tribunal. So the 29 capital A, my lord, clearly envisages the power of appointment, my lord. And your lordship knows that the power of appointment under Arbitration Act is either with this court or with the Honorable Supreme Court, my lord.
Yes.
So therefore, in the context, in my humble submission, in the context, the word court is used in 29A cannot be given defined meaning in 21E, 1E of the Arbitration Act, my lord. Why? Because for the purpose of the use of expression, my lord, 21E, because if the same meaning would have been required in all sections, then the legislature would not have used the expression, my lord, unless the context otherwise requires. The very is not considering 29A. This limit judgment is also prior to the amendment in Arbitration Act in 29A, my lord, 94-98. And this judgment, in my humble submission, also supports what I have been placing before your lordship. Kindly see. At page 95, my lord. An application has been filed by the appellants invoking jurisdiction of this court purported to be under section 14 of the Arbitration Conciliation Act for terminating the mandate of sole arbitrator, for appointment of substitute arbitrator, and also for withdrawal of the authority in terms of Article 8 of the appointment of arbitrator by the Chief Justice of India scheme. Indisputably, disputes and differences has arisen between parties that exist in arbitration and application under section 11(5), my lord. After all these five applications, my lord, kindly see paragraph 9. Paragraph 8, my lord. Application in terms of subsection 2 of section 14 thus lies before the court within the meaning of 1996 Act. Lordship has seen the Swadesh Kumar also, my lord, on this issue only. 11. As a code has been defined in 1996 Act itself, the application under 14.2 would be maintainable only before Principal Civil Court, which may include a High Court having original jurisdiction, but not this court. This court, passing the order dated as noticed here, did not and could not retain the jurisdiction in itself, as it would be done in suitable cases under 1940 Act. It even did not determine the validity otherwise the Arbitration Act. It allowed the parties to take recourse to remedies before the learned arbitrator. When the said order was passed, this court considered to have only an administrative power, but the same has since been held to be judicial power under so and so. 13. The definition of court indisputably would be subject to the context in which it is used. My lord, kindly mark these lines because I am also placing heavy reliance on this line. It may also include appellate court. Once the legislature has defined a term in the interpretation clause, it is not necessary for it to use the same expression in other provisions of the Act. It is well settled that meaning assigned to a term as defined in the interpretation clause, unless the context otherwise requires, should be given the same meaning. So this paragraph, my lord, is in my favor in the context of section 29A, my lord, and 29A, 6, 7 and section 11, my lord. So therefore this judgment also, my lord, cuts no ice so far as this judgment is concerned, my lord. And all other judgments also, there is no consideration of 29A, section 11, 29(6). The only judgment which consider all these aspects is the judgment of the Honorable High Court of Delhi, my lord. And my lord, and what we have done, my lord, by way of for the convenience, my lord, we have placed the relevant paragraph of all these judgments in my grounds, my lord. And, my lord, I am not replicating or repeating those judgments because there are judgments, series of judgments, my lord, which have followed Delhi High Court, which are in line with Delhi High Court judgment. Kindly see page 6 of my petition, my lord. Page 6 of my petition. This is the first judgment, my lord. Page 6, my lord. Page G. Page 6, my lord, ground G, my lord, that is Delhi High Court judgment, which I have already placed, my lord. I need not place the same judgment again, my lord. Kindly see the second judgment, my lord, at page 12. At page 12. Cabra. Yeah, my lord. Cabra, my lord. Then, my lord, page 13, Bombay High Court. Then 13, my lord, Nilesh Rambhai Patel, Gujarat High Court, my lord. I have quoted the relevant paragraph, my lord. And I have highlighted the relevant part also, my lord. So it's not the number, my lord, quantity versus quality, my lord. 16, my lord, page 16. So quantity I am also having, lord, quantity.
So we'll wait by the kilo, who gives more decisions, then, decide accordingly.
Wait by. So all these judgments, my lord, I need 6, 7. And then, my lord, 16 is Andhra Pradesh High Court, my lord. Calcutta High Court is at 17, my lord, ground K. And
what is wrong with the order of the
now kindly see
of the commercial court?
Yes,
then?
I am grateful.
You have not gone through that at all. You just blasted the court with judgments and interpretations.
Kindly see the kindly
What's
see
wrong with the order?
Yes, my lord. Kindly see the first. Kindly see there is no consideration at all, my lord. Despite I have cited.
The order?
I'm placing it, my lord. Kindly see. The impugned judgment starts from page 32, my lord. And at page 34, my lord, your lordship will notice that I have cited 6 judgments in support of the proposition that the High Court has the jurisdiction under 29A, my lord. And then after dealing all this, my lord, kindly see only 2 paragraphs where the consideration is there. None of my judgments have been.
Page?
Page 43, paragraph 18. Now 17, the argument of the respondent has been noted. The basis is, my lord, as rightly pointed out Mr. Prakash, learned counsel, in all the judgments relied upon by the applicant, arbitrators were appointed by the High Court. None of the judgment dealt with
this case appointed by the parties themselves.
Parties, my lord, parties.
Okay.
Dealt with a situation where arbitrators were appointed under 11.2 of the Act, as amended. Be that as it may, Section 2E has clearly defined 2 categories of courts in case of domestic arbitration which would have jurisdiction. Principal Civil Court of original jurisdiction and the High Court in exercise of original jurisdiction having jurisdiction to decide the question forming subject matter of, if the same had been subject matter. The High Court of Meghalaya does not exercise ordinary civil jurisdiction in respect of subject matter of arbitration in the state of Meghalaya. The argument advanced by the petitioner that expression court used in 29A of the arbitration does not mean principal civil court in district section 2E is not in line with intention of the legislature. Had the legislature intended to house the jurisdiction of principal civil court in the district under 29A, same would have clarified in the statute itself as had been done in section 47, wherein the legislature inserted an explanation clause. Thus, there is no ambiguity in the interpretation of the code under 29A. The interpretation of 29A has to be made in accordance with the definition of 2E. In my consider, it would mean principal civil court of original jurisdiction. And 47, my lord, is in part B, not in part A. And that is for purely commercial. And my lord, one more thing, my lord, on the last date of hearing, learned senior counsel for the respondent, my lord, pointed out that 29A, because Delhi High Court judgment refers to international arbitration clause, my lord, 29A was amended only in 2019, my lord. Kindly see that amendment. Yes.
Inserted in?
2015 and amended in 19, my lord. Kindly see. So therefore the international, because the issue was, my lord, that so far as international commercial arbitration is concerned, my lord, appointment is by the Supreme Court.
Yes.
And domestic is by the High Court, my lord. So the justice in the Delhi High Court judgment, my lord, in that judgment, both when the proposition was being discussed, in that case the High Court said that when the arbitrator is appointed by the Supreme Court under section 11, that arbitrator cannot be replaced by the principal civil judge, my lord. Because at that point of time, there was no such amendment in 29A, so therefore in that context those expressions have been used, my lord. So therefore the basic premise on which the judgment is based will not get altered or changed. And why this statement was, or why this expression was used in Delhi High Court? Because the amendment was carried out in 2019 only.
Yes.
Okay.
2019, both arbitrations required extension by the court.
So, my lord, if I sum up my argument, my lord, my argument is based on the holistic interpretation of the entire act, my lord. The judgment of the learned district judge is based on the defined meaning of court in section 21E of Arbitration and Conciliation Act 1996. Learned district judge has not at all dealt with the argument which required different meaning to be assigned to word court in section 29A. Different meaning to be assigned to the court, and that gets strength, my lord. I am fortified in my submission also on the basis that definition clause uses the expression unless the context otherwise requires. So in the context of the section, if different meaning is required to be assigned to the word court, the defined meaning in definition clause may not be applicable. And why it is not applicable, my lord? Because 29A, 6 and 7 both use expression appointment and also appointment and substitution. Appointment and substitution will get color and meaning from section 11 of the Act, my lord. Therefore,
so in your case there was no substitution, there was nothing. It's only that for extension of the time.
No, right now, because that issue may, because 29 they and we have to file reply on
but
merit.
The other view has to be considered also.
The other view is based on the premise, my lord, that the High Court is not having the principal
correct,
original. So that view, my lord, because that view is the only basis of the other view is, my lord, in my humble submission, is based on that the High Court is not having original jurisdiction, my lord. In the case of Delhi High Court also, my lord, the Delhi High Court was not having pecuniary jurisdiction to deal with the matter, my lord. Because that the Delhi High Court in that case also was not the original civil jurisdiction so far as that case is concerned. But everything turned on the interpretation of word court and in the context in which it should be interpreted, my lord. And it has got.
I think I understand submissions.
And yes,
it's a question of interpretation and application.
Yes, my lord. And it has got wide, far-reaching ramification for all arbitration proceeding in the state of Meghalaya, my lord.
How?
Because in future where the application under 29A would lie before the principal civil judge or before this court, my lord. So whatever authority pronouncement will come from, that will be followed.
Yes.
That has got bearing, my lord, because in other matters also, my lord. So I am grateful, my lord, for
yes, Mr. Banerjee,
giving patient hearing.
My lord, it's a interpretation which my lord has to consider, my lord, of the Arbitration Act. So, my lord, my lord, only one request I have, my lord. Today, my lord, unfortunately, my lord, I have, my lord, a matter fixed, my lord, now where the Attorney General of India is here. So I will request him if it's possible at 2 o'clock today. I don't know whether will be sitting at 2 o'clock. I'm so sorry to make this request, but I'm just a little.
My friend will
2 o'clock,
be there.
I'll be back.
I have some matter, my lord, at 2 o'clock. So my friend will be here. He will be noting them. I will join.
Yeah, 2 o'clock.
I should be here exactly at 2. I'm so grateful, I'm so grateful.
What other matter? Number 4.
24? 24?
There's one matter where. Where were we?
So yes,
waiting for the RPA General. Yes.
Yes. My lord, I got the brief now. Suddenly.
Yes.
Actually, perhaps on the last occasion, somebody else appeared and said that should be. So that may be.
No problem.
So the affidavit, additional affidavit, my lord, that has been filed, and there you'll see, your lordship will see the photographs, my lord, which is clear proof of the fact that they are going ahead with the execution. Now, therefore, my
1 second.
Your lordship will kindly see the annexure B. That will be at page 7.
Yes. Yes.
So therefore, my lord, these are.
How do we see that this is for the? Can anything be made out from these pictures?
No, my lord,
some random shot of some GCB
no,
working
it's
somewhere.
Geographical locations, my lord. Your lordship will find in the picture itself the geographical locations are given.
Latitude, longitude.
And in the annexure
where
C,
the center is supposed to come up.
Yes, and in annexure C, your lordship will see if the latitude longitude is placed in the conversion, well, the name of the village also emerges, the Nongtrai village. That is a screenshot of the computer.
Yes.
So that is the proof that, my lord, there, and recently also, my lord, even after filing of the affidavit, my lord, the pictures were taken on 10th, 11th and 12th of March. And this will also indicate it was taken on the same location, my lord. They are going ahead with this thing and not coming before the Honorable Court, although they have been served.
This is on 10th.
Yes, 10th, 11th and 12th. There are 3 sets.
Yes, Mr. It is true. Yes, it's already settled. The contract is settled with someone.
The contract is
with whom? Number 7.
Number 9.
Number 9.
Number 9.
My lord.
Who's number 9?
Number 9, my lord.
Address is not complete, my lord. Taiban, Warjari, Cleve Conley.
So that is the address in the tender document itself, sir.
But because the service has to be effected.
No, that has been done. Well, the service report has also come. Your lordship may kindly see the yesterday's office note. That indicates that the AD card has come back after being duly served.
If I understand correctly, my lord, the case of the petitioner is that he was not called for
negotiation,
my lord, and he is not the
One second. What do you see back? Served 9/11. He's been served.
It's in part 3 file probably. Part 3 file.
How is one person receiving for this Taiwan Wajiri, respondent number
9.
9. Then for this other person,
they are all resident of the same area.
Another one for this calling star Sokumi.
Yes.
He's respondent number
11.
Same person received for his 9 and 11.
No,
Yes.
how can it be?
Well, they reside on the same area, my lord.
The same hill.
Yes. So all are in Cliff Colony, my lord. And my lord, one of the contentions that has been raised in the writ petition is also, my lord, all of them had raised a bid for exactly same value.
No, now see, you've seen the AD card.
Yes,
it's one person, some ADCR has received.
One person.
How can one person receive on behalf of two respondents?
It was sent by registered post, and this is very surprising. One person receiving for.
My lord,
that's why, my lord, the plea of
the collusion
and cartelization, my lord.
Now, collusion is not on the part of the at least private parties, my lord, because one person will receive for all.
No, my lord, I am not saying that on the MEPGC.
No, on the private respondent.
Yes.
On the private, that is also far-fetched in my humble submission, my lord.
You have a look. You see?
Yes. Well, my colleague has just shown me.
You just show. That is what.
This is something very surprising.
No, I hope someone has just signed randomly, on some notice.
And if my lord, if the records are called from my lord, I have from personal experience, my lord, I have seen there are many times, my lord, one person signing bids for all. This has happened in Mizoram. Mizoram also, things have happened like that.
I don't see anything
one
here.
One person signing the bids.
You see that ID card?
Yes, my lord.
It's signed by some DCR for two persons, for the first
and
the third.
Yes. And who is DCR, my lord?
No, that has to come from the postal department. It was effected by postal department.
Exactly. I mean, whether the only concern of the court right now is whether we can take this to be, effective service. That's the only thing.
Yes.
That's only at that stage.
Yes.
Because that's the only why. Paramphasai, like, how can one person randomly sign for 7, sign for 9?
But then this was also served. The service was effected by the postal department, a neutral party.
Therefore, let them serve by Dusty, my lord. They can serve in Dusty, and then the party will be here, my lord.
Therefore, my lord, the plea of collusion.
But a time factor, you see, because if the matter still sees...
Only two submissions, my lord. What I see from here in paragraph 13, my lord, the allegations. Kindly see page 16, paragraph 13, my lord.
Yes.
The first allegation is that, my lord, paragraph 13, page 16. Nine from among us, the three bidders who had quoted identical rates clearly hints nepotism being adhered to the respondent authorities. Now, the question which arises, my lord, for your lordship's consideration is that petitioner is also a bidder, my lord.
Yes.
And his bid was higher than the bid of
10,000 higher.
Higher than so if the bid is higher, my lord, and I have given a bid to the lowest, the person who is having bid lower, can he make out a grievance because others have made the same bid? On the same amount, there are two bidders.
He wants to lift the veil.
That's
so even if the veil is lifted, my lord, I take it, my friend.
it is under careful cover by my learned friends.
No, even if the veil is lifted, my lord. If I take, my lord, that veil is lifted, and they are having some same colony because a small place, my lord. They have submitted same bid. What is and same amount, my lord.
So this person, DCR is behind everything. Or to receive or notice. He's one.
I'll play, my lord. What I can do, my lord. On Monday, what I can do, my lord, I will place the entire file, my lord.
You place the entire file Monday.
I'll place the entire file.
Not Monday, on Tuesday. But Monday,
I'll ask.
My lord, can it be on
Tuesday? I've got one matter before Jharkhand High Court Chief Justice, my lord. So whatever my friend will be there, who will.
But my only submission is that, my lord, till the time your lordship decides the matter finally, my lord, there should be some order, some restraint order on the respondent number 9.
Would amount to allowing the
whatever it is, if whatever construction, there'll be their loss.
That your lordship may kindly spell out in the order.
Your lordship has already said so. Your lordship has said so that it will be subject to outcome.
Yes, subject, yes.
And whatever loss,
outcome, whatever consequential.
Or whatever.
Learned Advocate General, after hearing at some length and after examining the affidavit filed by affidavit brought on record by the writ petitioner with regard to the commencement of the work, stop, and also on the assertion that.
I'll do it.
On Monday.
Wednesday is fine.
No, but Tuesday and Wednesday I'll be in Arunachal.
Thursday.
No, after examining the affidavit.
Thursday I haven't got a matter fixed here.
India on the case 26th.
No, listen, I'm not aware about that. After hearing at some length, the Learned Advocate General undertakes to produce the records with regard to settlement of the bids. So this when?
26th. Well, my learned friends.
26.
Very difficult, Milord. For me,
difficult because it will be closed.
26th.
Good Friday.
Oh, this whole week is closed. This whole week.
26th of April.
No,
that's
26th of yes.
26th is open.
Oh, sorry, open yes.
No, my lord,
right.
the holiday has been declared.
Yes.
Yes, this whole we are having some break, my lord.
Oh
So,
yes.
On 18th, in that case.
18 will be difficult because this court.
22nd.
22nd, okay.
22nd. All right.
22nd. But one word from your lordship, my lord. The
it's already there. If they're not wiser to that, can't make them any more wiser. It's only the consequential.
Sometimes one word from your lordship helps in understanding it in a better perspective, my lord. Only because your lordship has seen that despite that order that observation being there, my lord, and they're carrying out the construction was to commence in the month of October last. They were sitting over the matter for so long.
So the contract settled when?
This was just in February. It was to be settled in October last. They were sitting over the matter.
They are not the highest bidder, my lord. They are not the lowest bidder. And they
see, Mr. Datta, you must be alive to the fact also that they are the owners of the work, correct? And then the play and the joints also, since they own it, they can decide. So it's no hard and fast rule that says that binds them. That that is why this court's a bit hesitant on passing any restraining orders. Asking for stop construction.
And because
if there's blatantly in the face of the record something made out that they've gone against all set principles and settled the contract with the.
No, why did?
Another thing is that which. That if you can affect personal service, then we can bring them to court at least on that day.
Your lordship may kindly observe that personal service is also.
No? Yes, as there is some doubt with regard to the the service of notice upon the private respondents, the petitioner is directed to effect personal service upon the respondents 9 to 11 within 2 days.
And I'll also submit an affidavit of due service.
To file a service affidavit thereon. Yes.
Obliged.
Supplementary list, item number 3.
They probably, I think, you ask your junior what "de por me" means in Kannada language. So I think I don't think we can take it up now, because the other one's continuing. But the other one's older here. That 2 o'clock they're replying in that arbitration matter.
Tomorrow, my lord.
No, we'll take a chance. After, if he concludes fast, then we'll take it up.
Yes, I'll be there. I'll be here, my lord. Because since we have done, my lord, substantially.
You ask her, yes, what "de por me" means. Yes.
26.
Your Lordship, I'm praying for 1 week time, Your Lordship.
You're very happy to give time. This case for dismissal, you know that.
Lordship, I have already filed my written argument also. I have nothing to submit and the matter was already heard.
Why? Okay, 1 week's time. On the prayer of the respondent.
28.
Yes, we came to learn, Your Lordship, that the government has taken a decision, Your Lordship, for relaxation of age. So till now we haven't received a notification. So if my learned friend could bring that notification, sir, we will come to learn.
Relax age for you only.
Pardon?
Relaxation of age regard?
That's why, Your Lordship, we don't know whether it's for a particular department or for the whole, Your Lordship. So
Your Lordship, in my affidavit also I've stated, Your Lordship, that the government has taken the upper age limit for entry in government service has been relaxed.
Yeah, that has been raised across the board.
Yes, Your Lordship.
So now you'll come within the you'll come in the zone of consideration.
Yes, that's my instructions, because my claim.
No, what's your age now?
It's about 40, I think, yes.
40?
Yes, 40 plus.
Upper age limit is 37, Your Lordship.
So he's off the grid.
Yes,
Yes.
Your Lordship.
So they came to learn, Your Lordship, recently that the government has taken the decision, Your Lordship, but no notification has been issued.
Your Lordship, I can take instructions if there's any specific order in this regard.
No, because you were saying that although there are some people who are appointed who are overaged.
Yes.
Yeah. If you overaged, you overaged. What to do? Because you are claiming because you went for training.
Yes.
These are similar cases, I think. There's some other case earlier on that you gone for training, so you expect appointment, legitimate expectation. Correct? But now after you finish your training, but now the vacant posts have been filled up.
I'll have to take instructions, Your Lordship, on that.
1 second.
Your Lordship, the advertisement that was issued also, Your Lordship, we had clearly stated that the department will not bind itself into providing job for after successful completion of training, Your Lordship.
Yes, that is understandable. Advertisement was made when?
2006, Your Lordship.
2006 advertisement.
This is the advertisement that they've annexed in their petition. This is part also, Your Lordship.
Contemplating to make advertisement. Is that your case, I think?
Your Lordship, let it come next week, Your Lordship, because this matter was leading by my senior, Your Lordship. I have. So let it come next week.
Now you are the leading counsel from your chamber, I see.
But this matter, my senior will be doing, Your Lordship. Let it come next week, Your Lordship.
Because if you're 40 years old, then it's just, sometimes luck does not favor some people. That's all. Yes. We finish them all by 150. After 1 week.
29.
At the request of counsel of the petitioner.
May it please Your Lordship. Your Lordship, we're having difficulty trying to get in touch with the...
You can't get the legal heirs also?
No, Your Lordship.
Why?
We're having difficulty getting in touch, Your Lordship. I pray for 3 weeks' time, Your Lordship.
Yes, Mr. Lamsang, the counsel response 3 and 4 submitted. In spite of best efforts, they have not been able to obtain the date of the expiry of the response 3, and both of them died.
Yes, Lordship.
As also legal heirs. He prays for a lot. How much? Further?
4 weeks, if possible, Your Lordship.
4 weeks' time. Praise all this matter after 4 weeks in the order column.
I'll be blessed, Lordship.
34. May it please Your Lordship, I'd beg to mention that there has been a slight difficulty on the part of our senior Lordship since he had to leave for Umroi for the joint inspection that was to be carried out today. So I pray if this matter may be listed after a week.
After 1 week.
36.
My Lord, I am appealing in the matter for the petitioner, my Lord.
Yes, here the union is not available, Dr. Saraf.
My lord?
Dr. Mosika is not available right now.
Okay, my lord.
It was the first time to come for hearing.
My lord, on the last occasion, number of times it came.
Yes, admitted, yes. We thought we dispose it of, but then they said, let's hear it. We'll have it after 2 weeks then. Yes. Due to unavailability of Dr. N. Mosika, learned DSGI, this is matter for 2 weeks for hearing, yes.
38.
Please, Your Lordship, 1 week time may be allowed.
It's a fixed matter today.
Yes,
Fixed by whom? By you?
No, the other side, Your Lordship.
It's going for inspection, Your Lordship,
One inspection?
of the airport matter.
Oh, okay, after 1 week. As Mr. P.O. is not available. Gone for inspection?
Yes, Your Lordship.
39.
Last one. Here also gone for inspection. This matter is just amount. We're going to give Mr. Dasgupta.
Your Lordship, but as of today, Your Lordship, no orders in this regard may be passed. Just to record that the learned DSJ is not available. We can take it up a week later, Your Lordship.
We'll take it up on Tuesday.
Your Lordship.
If not, they want to do.
Then after 2 weeks, my lord, Tuesday.
Why? Where are you going? Going for vacation?
No, 120th I am going.
Yes, for vacation?
For 3-4 days.
Okay, after 2 weeks, yes.
After 2 weeks, yes. Much obliged.
Now, this betel smuggling has become a menace in the state of Meghalaya also. All the betel farmers are crying. They're not being. I saw the newspaper reports.
Yes,
they're just lying in the tree now. Anyway.
Much obliged.